The Government of India Act 1935. The Government of India Act was passed by the British Parliament in the year 1935, which had 321 sections and 10 schedules. The key sources for the Act of 1935 was A. Simon Commission Report, B. Discussions at Third Round Table Conference, C. Reports of Joint Select Committees, fourth, the White Paper of 1933. Now let us discuss the features of the Government of India Act 1935. The first point, introduction of federal system. A. The Act of 1935 provided for a federation which had 11 provinces of British India, 6 Chief Commissioners provinces and princely states. B. The accession to the federation was voluntary for princely states. Second point, provincial autonomy. A. The Act of 1935 gave more autonomy to the provinces. B. Diarchy was abolished at the provincial levels. C. The governor exercised executive authority over the province. D. The governor was required to act with the advice of the ministers who were responsible to the provincial legislature. Third point, diarchy at the center. A. The Governor General exercised executive authority at the center on behalf of the Crown. B. The subjects under the federal list were divided into and transferred list. C. The Governor General dealt with matters like tribal areas, defense, external affairs on the reserved list with the help of 3 councillors who were appointed by him but were not responsible to the legislature. D. The Governor General also dealt with matters like forest, education, health, local government on the transferred list on the advice of the Council of Ministers whose number could not exceed more than 10 but who were responsible to the legislature. E. The Governor General could act contrary to the advice given if it involved his special responsibilities. Fourth, Bicambral Legislature. A. The Central Legislature was bicambral, consisting of the Federal Assembly, that is the lower house, and the Council of States, which was the upper house. B. The Provincial Legislature was bicameral, consisting of the Legislative Assembly and the Legislative Council. But they were introduced only in 6 provinces like Bombay, Bihar, Madras, Bengal, Assam and United Provinces. In the rest of the provinces, the legislature was unicameral, that is, the presence of only one chamber. D. The legislative powers of the central and provinces were subject to limitations. First, a bill passed by the central legislature was subject to the Governor General and the Crown's veto. Second, the Governor General, if satisfied that the bill would affect the discharge of his special responsibilities, he could prevent the discussion of the bill in the legislature and suspend the proceedings. Third, the Governor General had the power to issue ordinances when legislature was not in session for the discharge of his special responsibilities. Fourth, the Governor General prior sanction was necessary for a bill or an amendment to be introduced in the legislature. Fifth, the bills relating to a number of subjects, such as those derogatory from the powers of a high court or affecting permanent settlement, when presented to the Governor General or Governor for his assent, were to be reserved for the consideration of the Governor or the Governor General as the case may be. Fifth point, powers distributed between centre and provinces. A. The federal legislature had powers to legislate on subjects in the federal list, 59 items, like external affairs, currency, coinage, military, etc. B. The provincial legislature had powers to legislate on subjects in the provincial list, 54 items, like police, education, etc. C. The federal and provincial legislature had powers to legislate on subjects in the concurrent list, 36 items, like marriage and divorce, criminal and civil procedure. D. The federal legislature had the power to legislate on subjects in the provincial list if an emergency was proclaimed by the Governor General, and also if the legislatures of two or more provinces so desired in their common interest. E. In case of conflict over the provincial and federal law on subjects in the concurrent list, the federal law prevailed. In case the provincial law was reserved for the consideration of the Governor General, and if the law received his assent, then the provincial law prevailed. F. The residuary power was not vested in either the central or the provincial legislature. The Governor General had the power to authorize either of the legislature to enact a law. Sixth point, federal court. A. A federal court was established at Delhi. B. It was established for the resolution of disputes between the centre and the provinces, and also between provinces. C. It had one Chief Justice and not more than 6 judges. Other important points. A. The Indian Council was abolished. B. Direct elections was introduced for the first time. C. Separate representation for Muslims, Sikhs, Indian Christians, Anglo-Indians and Europeans was created. D. The Dominion status was not given, though it was promised by the Simon Commission of 1929. E. The proposal for setting up a federation did not materialize because the princely states were given the option to join or not to join, and so the required number of princely states did not join the federation. F. The partial reorganization of the provinces led to separation of Sindh from Bombay. Bihar and Orissa were split into separate provinces, and Burma was separated from India. G. The Federal Bank was established. The Government of India Act 1935 played a very important role while framing the Indian Constitution.